So we spent some time talking about race discrimination, and now we're going to look at sex discrimination. But as we will see, the problem of sex discrimination is much larger in some ways than that of racial discrimination. Now, remember, sex discrimination was added to the statute at the last possible moment. The statute did not include protection based on the protected category of sex, and in fact, it was added to the statute as what we call a poison pill. It was meant to kill the statute. That although people may be willing to vote for a statute that included protections against race discrimination, no one would vote for a statute that protected against acts of sex discrimination. So sex discrimination, of course, was a last-minute addition to the statute. It was literally added the day before the final vote. And so no one really knew much of what it meant. What do we mean to not discriminate on the basis of sex? Because we know that sex discrimination is going to differ in significant ways from race discrimination. When we talked about race, we said it was an invention, and it was a relatively recent invention, and it was non-scientific, and it was created only to justify the institution of slavery, and that the drafters of Title VII envisioned a future where race was not an issue, that we were colorblind, that we did not look at matters of race, that the whole concept would eventually fade away. Well, when it comes to sex discrimination and the concept of sex, of course, you're in a very different situation. Not only do you have the basic biological differences involved, you have cultural differences based not on 400 years of Western European culture, but instead on worldwide notions of sex-based behavioral differences between men and women. And so what does it mean to not discriminate on the basis of sex? Well, sometimes it means don't think of the person's sex when making an employment decision, but then other times it means you must think of the person's sex when making an employment decision. And I'll talk about that in a second. But we know that this protection against discrimination was a last-minute addition to Title VII, and courts have struggled with balancing societal interests, that how much of society's expectations should we respect versus how much are we going to be limited by what the law provides. And so courts have gone back and forth on this concept of what is sex discrimination. What is, how are we going to take into account societal differences, societal interests, something like different bathrooms for men and women. You know, if an employee of yours came to you and said, look, I think we need different bathrooms based on race, that people should go to the bathroom of their designated race, well, you would fire them. You'd say that's a terrible idea. And you didn't need to take this class to know that's a terrible idea. But when it comes to men and women, in fact, sometimes you must provide separate bathrooms. There was a case back in the 1970s involving the Tennessee Valley Authority. And the Tennessee Valley Authority, it was actually a subcontractor of the TVA. And the contractor was building a new facility for the TVA. The TVA is the institution that brought electrification to rural areas of the South. And so this contractor was building a new facility. They were away from any local town. It was sort of out in the woods. And the contractor had hired the first women ever to work on this crew. It's 1974, so Title VII has been in place for a while, and therefore they eventually have hired females to work on the crew. And the women are expected to use the same porta potties as the men. There's a row of porta potties out there for all the employees, and the instruction from the employer is everyone has an equal right to every bathroom. Now there's 2 women there and dozens of men. And the 2 women say, can we just set aside one of the porta potties for only women? Because, it's a porta potty, it's a terrible place, and the men, the male employees, were leaving them in, of course, terrible condition. And so they said, look, we just want to have a place to use the facilities in peace. And the employer said, no, we cannot do that. We are not going to discriminate on the basis of sex, and everybody goes to every bathroom. Therefore, there's no sex discrimination. How can this be sex discrimination? So the women start by simply going to use the facility of the local TVA office, which is a short walk away from the new facility. And the TVA office complains to the to the contractor, saying, look, this is not for, this is for only clients of the company. It's not for construction workers. They can't go to the bathroom in our main building. And so then the women start to wait until their break, and then on their break they will drive about a half a mile down the road to the local convenience store. They'll go to the bathroom, and then they will come back to work. And the contractor says, no, we can't have that, because we have a rule that says once you're on the work site, you have to remain on the work site until the end of the day. If you leave the work site, you can't come back. And so the women then are forced to either use the unhygienic facilities that are in place, or to simply hold it for as long as they can. And so one of the women actually develops physical issues from not urinating when she should urinate because of the bathroom. So they file the lawsuit. And again, the defense of the contractor is, look, we are not discriminating on the basis of sex. We are literally not discriminating on the basis of sex. But what the court said is, look, women working there are facing a different issue than the men. Women are being required to use facilities in a way that is damaging to them, and therefore that constitutes sex discrimination. Women are being given, the terms and conditions of the women's employment are different than those of the men, and therefore that's sex discrimination. So if you want to look at the differences between sex discrimination and race discrimination, think of those bathroom cases. And these gender-related claims continue to increase. If you follow the news at all, you know that there's been a lot of discussion about sex discrimination. And in fact, I think it's fair to say now that sex discrimination has become the predominant focus of Title VII, whether sex discrimination or sexual harassment. So in this lecture, we're going to look at the basics of sex discrimination. Now we know that Title VII prohibits discrimination in employment based on sex. Nevertheless, sex-based differences in the workplace continue. The law prohibits discrimination on the basis of sex and employment practices, but sometimes that can be hard to determine. In this case, involving the city of Kansas City, 2 female firefighters worked for the Kansas City Fire Department. And if you know how firefighters work, they usually work in 24-hour blocks. They'll work 2 or 3 days on and then have 4 days off. And so they are living at the fire station while they are on duty. And then they're eating there, they're taking showers there, they're living at the fire station for those 24-hour periods, 48, 60, or 72 hours. And in this case, the 2 women were working there. Now, the fire department had a policy involving the firefighting suits. If you know anything about firefighting suits, you know those are very expensive. That's a $2,000 suit designed to protect the firefighter. And so the city of Kansas City had a policy that when a new person was hired, and therefore they had to purchase a new suit, that the newest suit would go to the most senior employee, and then his suit would go to the one below him, and thus down the chain, such that the new hires wound up with the oldest suits. Now, these two women are taking part in that same policy, but what it means is that because of biological differences, the suits fit differently on the women than they do on the men. And so the women are being required to use suits that are not fitted properly. They also have a claim that they don't have a separate bathroom facility in order to shower. And so what they would do is when one of them goes to the bathroom, the other would stand at the door and guard the door, and then they would switch places, and then the same with the shower. But in any event, it was a very different type of employment than the male firefighters were getting. So again, this is a situation where the defendant, the employer, the fire department says, look, there's no sex discrimination. This is a neutral policy. It applies to everybody. Everyone wears the hand-me-down firefighting uniform of the next most senior person. But what the court says is, look, this involves safety and health issues. That women are being required to fight fires in ill-fitting uniforms. They are facing a different type of employment than the male firefighters, and therefore that is sex discrimination. So it can be tough. This is tough in terms of determining what is sex discrimination, because we're saying don't take sex into consideration, but at the same time be sure to take sex into consideration in terms of making employment decisions. And sometimes policies may not appear to be illegal or be intended for illegal purposes, but have that effect. This case, Dotard versus Rawlinson, is one of the famous disparate impact cases. Ms. Dotard wanted to work as a correctional officer for the state of Alabama. And so she applied for the job, but was denied based on certain physical requirements that the state had in terms of you had to be at least 5'4" and you had to weigh at least 125 pounds in order to be a correctional officer. Now, no one's quite sure where those numbers came from, but those had always been the numbers used. And again, those numbers were meant to be neutral, that any woman over the more than 5'4" could apply. Any woman who weighed more than 125 pounds could apply. But instead, what happens? The classic disparate impact. A neutral policy that has a disproportionate impact on women. So even though the policy was not intended to be illegal and had been in place for years and years, it had the same effect as a policy designed to exclude women from the workplace. So when can we use sex? Well, sex can be a BFOQ, meaning we can cite a BFOQ. You must be of a certain sex, but those are very rare. BFOQ, remember, is not available for race or color discrimination. It's only slightly available for sex if you can show that having to hire a member of one sex goes to the essence of your business, that it is impossible to hire someone of the other sex based on concerns about the business. So where would we see this? Well, as we'll go through these, you'll see there was a lot of cases involving things like flight attendants that had historically been closed off to male applicants. However, so we know that those are not going to succeed. We have had cases that involving morality For instance, if you were if you had a lingerie store and you wanted to hire people to work with the customers who are buying lingerie, you may be able to claim that you have to hire a woman for that position, but you're going to have to be able to justify that. It usually is only in certain limited circumstances. Say you it's a medical facility and you're working with some type of radioactive isotope that could lead to birth defects in pregnant women, and since you're never quite sure whether a woman is pregnant or not, you simply have a rule that no woman can apply for the job. That may be rise to the level of BFOQ, but in essence, this BFOQ is very difficult to assert for sex. It's going to be much easier for national origin and be even greatly easy for religion or sex or age discrimination. So attempts to use a gender-based, a sex-based BFOQ rarely succeed. In this case, Diaz versus Pan American. Pan American, the airline at the time, had a rule that, like every airline, they would only hire women as flight attendants, that they refused to hire men. Mr. Diaz applied for a job with Pan Am and was denied. And when he filed suit, what Pan Am said, their argument was, we have to hire women for the job because women have a special caretaking ability that men don't have. That the fundamental nature of what a flight attendant does has to do with taking care of the passengers on the flight, whether that's serving them drinks or giving them food or helping them out of a burning airplane. They must take care of the passengers on the flight. And Pan Am says women have the ability to take care of people better than men, and therefore we must hire women for this job. Well, that goes to the court, and the court says, well, there may be more women who are good caretakers than men. At the same time, there may be men who would be excellent caretakers. And if you exclude them from even applying for the job, that's wrong. That's sex discrimination. And so even if you try and frame your BFOQ as something positive, you have to show that it's actually job-related or necessary. And if you look at what's essential to the job of being a flight attendant, well, it's nothing to do with sex. It only has to do with being a good caretaker. And that is, we can find examples of that in either sex. So a BFOQ may only be justified by necessity and not simply convenience. BFOQs may be supported by community standards of morality or propriety. That's the case of the lingerie store assistant. But that could also be subject to change and is going to depend on the community standards, meaning what is the standard in metropolitan New York City versus the standard in Enid, Oklahoma. So it's not going to be a simple, straightforward response. Another type of discrimination has to do with sex stereotyping, which is to say we cannot make decisions based on our stereotypes of how women should behave. We can't make decisions based on what we think a man or a woman, how we think they should act. That those stereotypes are also illegal discrimination. This sex stereotyping case came out of a case involving the accounting firm of Price Waterhouse. And in this case, Ms. Hopkins had applied for to be a partner at the firm. She had been an associate accountant for a number of years and wanted to become a partner. And becoming a partner is a big thing because it changes your employee status from, you change your status from employee to owner. And so there's a lot of money involved, there's a lot of prestige involved, and it's your whole future. And so Ms. Hopkins had applied for this position as a partner with a firm. And the firm had, what they did is they would send around questionnaires to all the other partners as to what they believed would be the outlook for Miss Hopkins as a partner. Would this person be a good partner for the firm to take on? And there were some mixed results. Some said she was doing great, she was doing a good job, she had a good client base, and therefore would be a good partner. Others criticized some of her efforts at work. And there were also criticisms of her as a person, saying that she was too brusque, she was too abrupt, that she needed to go to charm school, that she needed to wear more dresses and more makeup and present herself in a more feminine manner, because that's what people expected of their female accountants. And so the firm did not make her a partner, and she filed a lawsuit saying she is being treated differently than men in the same position, that those complaints about needing to wear a dress or makeup or go to charm school would not be the complaints made against a man, and therefore she was suffering sex discrimination. And so we have prevented sex stereotyping as an illegal form of sex discrimination. This Price Water case involved something called the mixed motive factor, which is to say, what does a court do if in fact an illegal factor was considered, something like sex stereotyping, along with legitimate concerns? Say, this person's not generating enough money, or this person doesn't have enough business contacts, they don't have a sufficient client base. Because those were some of the complaints about Miss Hopkins. Well, in the Supreme Court decision, there was, what the court said is, let's send it back to the trial court and let them figure out what was the dominant motive. Was the dominant motive illegal, sex stereotyping, or was it legal justifications based on work product or quality? Well, all of that went away as a result of the Civil Rights Act of 1991. The Civil Rights Act of 1991 said that you can never use an illegal factor in making an employment decision, and that if you use an illegal factor, even if it's incredibly minor, if it is 1% of your decision and 99% of your decision is based on legal factors, the entire decision is illegal. So keep that mixed motive problem in mind as you handle your writing assignments in this class.